If you've been separated for a while, you may not have gotten around to getting divorced. For some people, that's an intentional decision. They do not want to be divorced, or they do not want to accept that their marriage is over. For others, it is just procrastination. But is there a deadline for getting that divorce or dealing with the other legal issues surrounding separation? There can be some legal timelines that apply after separation. So in this edition of the Ontario Family Law Podcast, I will go over what they are. I'm Judge Schuman, a certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficult parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. My book goes over the family court process in detail and is an invaluable guide to get you where you need to go after separation. Today we're diving into a crucial topic that affects millions of people every year: deadlines for getting divorced. If you're thinking about filing, already in the process, or just curious about how long it takes, stay tuned as we unravel the legal timelines, waiting periods, and practical tips for navigating the divorce process. Watch this video right to the end to make sure you do not miss any important points. Way back in episode 3, I explained exactly what divorce legally means. That was an audio-only episode, so look for it on your favorite podcast service. To summarize, divorce means that you are no longer married, so you can marry someone else. It means little else. Often, the only other legal significance is that getting a divorce cuts off your spouse from your employment benefits. If there's a need for those benefits or medications or other crucial needs, then the divorce may have impacts on spousal support and other claims, but usually it just lets people get remarried. And if they do not want to get remarried, then they do not need to get divorced. Still, waiting too long can cause problems. Immediately after separation, a spouse may think that he or she will never get married again. But several years later, after things have settled down and they get into a new life and they meet someone new, getting married can seem very attractive. But that remarriage cannot happen without getting a divorce. Getting a divorce may not involve actually appearing before a judge, but it does involve getting a judge's order. To get an order, you must serve the other spouse. If it has been a long time and you don't know where the other spouse is, or if that spouse has left Canada, then getting that divorce can be a real headache. It may even give your ex an opportunity to get the divorce somewhere else, in a jurisdiction where the terms can be much more favorable to your ex. Check out my episode on where to get divorced for more information about that. So even if you do plan on getting remarried, it is best to get divorced while you still know where your ex is. Also, if you do find yourself suddenly wanting to get remarried, you need to consider that if you are not divorced, getting that divorce can take some time. In an earlier episode, I explained how long it can take to get divorced in Ontario. Check out that episode for all the details. To summarize, separated spouses must be separated for at least 1 year to get divorced. Then it can take some time to go through the steps of getting a divorce. Think months, not days or weeks. So when planning to get married again, those timelines are something to factor in when getting divorced. Many people think of the other stuff that surrounds divorce when they think of divorce. Those are things like parenting orders, child support, spousal support, and property division. However, those are actually separate legal issues from the divorce, and they can have their own legal timelines and deadlines. Before we get into that, remember that there are a lot more legal tips and good strategies for family court, family arbitration, and even mediation and negotiation in the more than 100 episodes of this podcast. So please subscribe, hit the like button so other people in similar situations will get this advice, and ring the notification bell so that you know as soon as new episodes come out. You may also want to pick up a copy of my book. In addition, you can get a lot more Ontario family law information on www.schumanlaw.ca and on my social media feeds. Check out my Facebook page, follow me on Twitter and Mastodon at @SchumanFamLaw, and find me on LinkedIn, Blue Skies, and Threads. Firm deadlines. There's some hard and fast legal deadlines for making some claims after separation. For other claims, the law changes what the results will be with the passage of time. So waiting too long can be a very bad idea. For property claims, there are absolute legal deadlines after which a separated spouse loses the right to make a claim. For equalization of property after marriage, there is a clear deadline. Separated spouses cannot make that claim anymore once 6 years has passed from the date of separation or 2 years has passed from the date a judge granted a divorce, whichever is first. That deadline can be extended a little if the separated spouses are actively negotiating towards a final settlement, but it is always best to just assume that once the deadline has passed, a spouse loses the right to make a claim to equalize the growth of the parties' net worths during the marriage. That can be a lot of money that just disappears once the deadline passes. Other claims have shorter deadlines. Most tort claims must be brought to court within 2 years of the incident. Tort claims that come up in family law cases are things like battery, intentional infliction of mental suffering, intrusion on seclusion, which is invasion of privacy, and other wrongful acts designed to harm the other spouse. For a spouse to include those claims in their divorce proceeding, the wrongful act must have taken place less than 2 years before. Claims that get harder over time. Another group of claims that get much harder to make as time goes on. The first of these is parenting. In my episode on whether a spouse should leave a matrimonial home on separation, I went over how doing so can create a parenting regime that can become hard to change for the parent who left the house. A similar sort of thing goes on if the parent wants to change the existing parenting arrangement but waits to do so. The longer the children do well in a parenting arrangement, the harder it is to change those arrangements. Judges have even said that a without prejudice parenting arrangement, in which one parent specifically says that he or she disagrees with the arrangement, can be hard to change if it goes on for too long. The courts have recognized that intervention is required quickly in parental alienation cases. If the parental alienation is allowed to continue on too long, the children's views become cemented and impossible to change. So any parent who is a victim of parental alienation must rush to get the court to help them, or there will be nothing that anyone can do to fix the situation for the kids. Spousal support is another claim that gets weaker over time. In the audio episode where I explain spousal support entitlement, I explained that there are compensatory, non-compensatory, and contractual grounds to spousal support. The non-compensatory grounds are based on a spouse's immediate financial needs. But if the spouse is able to look after him or herself for a while before making the claim, it seems like he or she needs less support. This is particularly a concern on motions for temporary spousal support before a trial, where the temporary support order is largely based on a spouse's need for support. If a spouse goes a long time without bringing a support motion, it can look like he or she does not have a big need for support. If the spousal support is based on contractual grounds, waiting can look like a waiver of the contract term. Claims without limits. And there are some claims that are not supposed to disappear with time at all. One of these claims is a claim for retroactive child support. After the Supreme Court of Canada's decision in Colucci made it clear that the law requires child support payers to pay the right amount regardless of what the order or agreement says, when a support payer pays too little, the parent who should have received child support can go back and seek that child support whenever the recipient realizes that he or she should have been paid more. Although, like with the claims I mentioned before, judges get reluctant to go too far back and look for ways to limit the amount of retroactive child support if the recipient waits too long to seek an adjustment. Summary. While there is no deadline for getting an actual divorce, if you wait too long and your ex disappears or leaves Canada, it can be very difficult and much more expensive to get that divorce. For other separation-related matters, there are firm timelines for when you must go to court, and if you miss them, you lose your claim. For other issues, especially parenting and spousal support, your claims get weaker, sometimes much weaker the longer you wait. But still, court is not for everyone, and for some it can be a very bad decision. Check out my episode that explains why, and lets you know if court is a good or bad decision for you. But if you have any doubts about what you should be doing, then speak to a good family lawyer who can give you advice that's specific to your situation. You can reach me by emailing john@schumanlaw.ca or calling 647-342-6775. To get a lot more information on how to succeed in family court and a detailed description of the family court process, or important information on parenting matters after separation, and information about child support, spousal support, other financial matters related to separation and divorce, get a copy of my book, The Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook Store and Amazon for the Kindle version. Amazon can deliver the paperback version directly to your doorstep. Check me out on social media. And please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They are also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.